how constitutional values become rhetoric, and in the process how the Republic maneuvers the membership issue. So to compensate for the excess time taken by the speaker, I will not go further. I have many, in fact, perhaps queries, but so I will request Professor Somir Das to make his presentation.
Can I speak from there? Yes, for having invited me, and invited me as one who is not a legal expert, but who has some understanding of what I describe as legal anthropology or anthropology of law, which means that I will tell you a few stories from my own ethnographies which have been conducted in Assam, let's say between April and June, to the extent time permits me to do that. But a quick review of the way the relationship between citizenship and democracy is understood ordinarily in the course of the present debate, which addresses primarily to such questions as the preparation and updating of National Register of Citizens and the enactment of CAA. I think that if you describe democracy as a regime of rights, then the primary question is that whose rights, which rights are you talking about? Because those who are opposed to citizenship, they are also talking about rights, and those who are opposed to NRC, or for that matter CAA, they are also talking about rights. And those who are in favor of both these things, they are also talking about rights. So on the one hand, the argument is that if, for instance, quote unquote, the foreigners are allowed to come in, then obviously you know that Assamese are a small nationality that is going to be swamped, and eventually a rule of foreigners will be established. It's, for instance, estimated that in about 40 of the electoral constituencies out of 126 constituencies, the foreigners are in a majority. I don't know the statistical basis of it, but there is the real fear. So which means that they elect their own government, and they will make a mockery of our democracy, apart from certain other problems. So in that sense, you know that you require an NRC, and you require probably CAA as well. The other side of the debate is, and this is how the debate is understood in Bangladesh, for instance, and some of the activists in India as well, is this that Bangladesh is a victim of environmental degradation, coastal subsidence, climate change, and it's losing out land to the rising tides of Bay of Bengal, which means that by 2050 you may not have a country called Bangladesh. But on the other hand, the argument is something like this, that Bangladesh is not alone responsible for global warming and the consequences that the global warming induces. So which means what? That there has to be some sort of burden sharing. And one of my colleagues in the year 1996 actually wrote a provocative Bengali essay in which he said that the Bangladeshis have a natural right to migrate to the upper reaches of the Gangetic Delta, particularly the districts of Assam as well as the bordering districts of West Bengal as well, natural right to migrate. So they are also talking about rights. I think that the debate understood in these terms has hit a stalemate, which means that there is hardly any middle space which provides an opportunity for dialoguing between these two positions. So what I'm going to do is to sort of take the debate out of this stalemate and would argue that when people are decitizenized or are rendered stateless, that's what is going to happen to, let's say, 1.9 million persons whose names don't figure in NRC. Then obviously, what do? And this is where the importance of ethnographies has to be understood. what do? They are involved in, and I would borrow a term which Derrida has used, acts of citizenship. And by acts, I mean two things. One, that this is how they are involved in certain kinds of acts through which, I quote, rights-claiming subjects constitute themselves as political and enact themselves as citizens, unquote. Which means that they are not citizens per se, but they try desperately to become citizens. That's one part of the story. So how do they try to become citizens? And the second thing is this, that these acts per se are not unconstitutional or illegal, but they continuously test the law at its limits, try to push the ambit of law, stretch it further and further. And I quote a particular sentence that Derrida has used in his acts at the moment, but law is what it has the potential to become in future. So becoming law is a way of becoming citizens as well. And I will try to sort of draw three examples from my own ethnography. One is this, that in 1997, and this is quite known to all of you, in France, for example, a number of immigrants took refuge in churches and cathedrals when the French police tried to flush them out. The movement is called sans-papiers. I don't know whether I'm pronouncing it in the French way, but basically the idea is without papers. So they are the people who are undocumented, who don't have documents, and who have taken shelter in churches and cathedrals. French police took some time to actually flush them out. Eventually decided to hunt them out of those places of refuge. The argument there was that yes, we are immigrants, but then we don't have papers. Nor are we obliged to show papers. And you know that the recent campaign of Kagoj Dekhabo Na, we are not going to show papers, is actually going in that direction. But they also argue that how can you describe us as unconstitutional or illegal? Because the French Republic is built on three basic principles of liberty, equality, and fraternity. And these are the three principles which are actually infinitely capacious to accommodate people of the world who are in search, who believe in or subscribe to these three republican principles. So even if you say that we don't have documents, your constitution is built on certain principles which actually are accommodative of us. This was the central kind of argument. Some months back, 5 persons, Subodh Das, Shamul Bishwas, Abhinash Bishwas, Ananta Bishwas, and Dhananjay Namashudra, in a remote hamlet of the district of Tinsukia in Assam, were lined up along the banks of the Brahmaputra and were shot dead from close range. The Chief Minister of West Bengal suspects if these were not the fallout of the zealous NRC preparations. I interviewed Ranjan Sarkar, the president of the Assam-based Bangali Janmukti Morcha, the Alliance for the People's Liberation of the Bengalis, and he told me, I quote, "We have suffered long enough, no more. We want to see the end to all this. If we do not receive justice, it will have dangerous consequences. This is not a hollow threat. We will prove it through our action." Mark this word, action. In other words, justice is always in an asymmetric relationship to law. And just the demands of justice would always test the law at its edges, at its limits. So this is one kind of ethnographic example that I wanted to share with you. The second is that in April, I was at a place which is in the district of Kachar, and the name of the place is Pailapul. It's literally on the Assam-Manipur border, overlooks Manipur, and is not too far from Jiribam. And I met someone, let's name him as Firoz, who lost his parents, who migrated from Bihar incidentally, and who lost his parents very early in childhood. So he migrated to Assam and decided to settle in this small hamlet. Now, why is this hamlet important? Because it is actually at the tangent of the great Asian highway that is being constructed thanks to India's Look East, or its new avatar, Act East policy. But there is hardly, as long as I stayed there for about 7-8 days, I hardly could see significant freight movement along this corridor, which means that the volume of trade is extremely low, notwithstanding the developed connectivity. The road is actually full of cow dung, and you see cows and bulls grazing around. This is significant because this is the face of globalizing India at one level. On the other hand, let me come back to Firoz. Firoz is illiterate, he can't read anything. When the final draft was prepared in 2018, he could figure out that his name simply doesn't exist in the NRC. So he was faced with two alternatives. One alternative is to migrate to Manipur, where the NRC preparations are not being held. But then there was a problem, because you know that during the last 5-7 years, the insurgents of the valley actually have killed a number of Bihari immigrants in Manipur. So it would be like from frying pan to fire. The second alternative was, and which he actually exercised, was to approach someone, a local leader, who was most vocal in favor of the updating of NRC. So what did he do? To cut a long story short, he had to do two things. One, he had to find out the name of someone whose name figures in any of the electoral rolls till 1971. But not simply a person, but a person who has deceased, number one, and who doesn't have any successor. This is how the legacy of a person can be thieved, can be stolen. It's widely circulated there. It's called legacy theft, that you can actually thieve the legacy of someone. And these names become very, very important in the preparation of the National Register of Citizens. And the second is, you have also to establish your linkage with that person. So faking linkage becomes the second step, that you have to fake the linkage. All the papers could be done, and Firoz tells me that it becomes easier for a Muslim to do it precisely because the Muslim children don't carry the surnames of their fathers. It becomes easier for them. And he could do it. Now he has become a citizen in the sense that his name now figures in the final version of NRC. But he had to pay a hefty price right through his nose. He was a day wage earner. And he has almost lost all his savings in the process. So this is the second ethnographic example of how you can become citizens by way of stretching and testing law at its limits. The third, which I describe as, and this is where I will stop, citizenship by death. That all of us have heard of citizenship by birth, but this is citizenship by death. I will take 3-4 minutes to wind up. Maluti Bala, a 52-year-old terminally ill patient suffering from end-stage renal disorder, figures in the list of the doubtful or D voter and is suspected of being a foreigner and was summoned by the foreigners tribunal for appearing before it with all her documents. She takes it as the ultimate humiliation of her life, and she is exceptionally sensitive about the fact that she is not regarded as a citizen of India. The rest of her family members do not have to suffer the humiliation of being branded as foreigners, because all of them have become citizens. Malatiwala regrets, quote, "One can suffer the bodily pain, but one can hardly suffer the pain of being suspected as a foreigner. I am sure to die, but let me die in peace knowing that I am a citizen of this country." So what she wants to achieve in life, many others could achieve by death. Let's see how. If Malatiwala keeps struggling for citizenship before she breathes her last, Dulal Chandra strangely struggles for citizenship even after his death. About 2 years back, a tribunal labeled Dulal Chandra Pal, a 65-year-old mentally deranged person from Assam's Brahmaputra Valley, a foreigner, in an ex-party case. Since then, he had been spending his days in the Tezpur detention center till he breathed his last on 13th October 2019. He fell ill while at the center and was sent to Guwahati Medical College, from where he could not return to the center. Government authorities made repeated requests to the family for receiving his dead body. Ashish, one of Dulal's sons, insisted that they were ready to receive Dulal's body on condition that he was declared an Indian in the first place. Ironically, Dulal's name was rejected after he had applied for inclusion in the NRC, in spite of the fact that he had had the deed of conveyance of the agricultural land in his favor way back in 1960. But there was some problem, in the sense that his father's surname was Rajvangshi and his surname was Das. So there was some sort of incongruity. Dulal's family, being one of Indian citizens, refused to accept the body of someone who was not declared an Indian citizen. The government of Assam set up a committee with the purpose of persuading the family to accept Dulal Chandra's dead body. Even a section of people's representatives also urged the government to send the dead bodies to their respective countries, of which they were believed to be the citizens. Chandramohan Patwari, the minister of the relevant ministry, however, replied, quote, "We do not check the citizenship of the dead persons in detention centers," unquote. Ashish Das, in his letter to the editor of Anandabazar Patrika, asks, quote, "Does this mean that one who is detained is a foreigner as long as one is alive?" Unquote. Dulal's close relatives have demanded that Dulal, more aptly his dead body, if not declared an Indian, be immediately sent back to Bangladesh. Sarbananda Sonowal, the present Chief Minister of Assam, expressed his grief in writing and assured the family that his government would fight the legal battle in Supreme Court, asking for an official declaration that Dulal is, quote, "posthumously an Indian citizen," unquote. Dulal's family agreed to receive his body after 10 days of his death, once the written assurance was given to them. Thus, Dulal Chandra's body after his death lives, as it were, with the hope of resurrecting itself by becoming a citizen of India, and in the process making the state bend on its knees on the new citizenship regime that it promises to introduce in Assam, and perhaps in rest of India as well. People like Dulal Chandra are the living dead that the body politic finds impossible to fully absorb and subsume. Thacker calls it a necrology of the core and describes it in the following terms, and there I will end, quote, "The core that which remains after life, after health, after the vital, this thing that remains becomes at once that which the body politic concept struggles against, and that which provides a promise of a more perfect, resurrected body. In a sense, the central problematic of the body politic is this ontomatical revenant, the body that remains," unquote. The democratic, so I perfectly agree with what Professor Krishnaswamy was arguing, that there is a fault line between constitutionalism and democracy, but I would say that democracy is not simply a regime, but it's also about rights and rights claiming people. So if this is so, then obviously you know that these rights claims continuously test the law and constitution at its margins. The democratic surge, whether in Barpeta in 2010, where for instance the pilot project of NRC was to be scrapped precisely because there was strong resistance, or Tinisukia in 2018, or in Pailapul in 2019, calls for redefining citizenship from a sluice gate meant for decitizenizing or rendering stateless the poor and the vulnerable, the paperless and the disenfranchised, and keeping them at bay, to an instrument for seeking justice. Democratic politics today, as we argue, probably exceeds the politics of citizenship. While democratic struggles and movements threaten to burst through the sluice gate, nation states will continue to defend it and keep the citizens from the outsiders as long as they survive in human history. Citizenship tragically is an aporia that is fated to redeem the pledge it makes to democracy, but always inadequately. Thank you very much. Thank you for your questions.
Thank you, Professor. That was really impressive. He basically dissected it from three vantage points, what I would call the wrong sides of rights, and what he calls law testing justice, and finally law testing itself, perhaps. And citizenship, as he shows, as he explores, becomes a technology for maneuvering of both sides, the state and the people. Now I request Professor Rukmini Sen to make her presentation.
Thank you, Professor Sinha. Shourab, and also Shourab for having me here, and also a huge thanks to the student volunteers who've been taking care of organizing this program and getting us here. It's always wonderful to get back to NUJS, a place where one began one's teaching career, and feel extremely humbled that a conclave which is being organized in memory of Professor Madhava Menon, there are some thoughts from a feminist perspective towards the sociological understanding of citizenship, democracy and constitution that I would be sharing here today. What I intend to do in the time that I have is to kind of pose the thoughts under two broad themes. One would be, and I think contradiction would be something which runs across both these themes. So one is contradictions at the becoming of the Constitution, during the framing of the process of Constitution coming into existence. And the second is the women's question in the Constitution and understanding both contradictions and resistances to it. And I think as I do both, there is a certain way, maybe the contemporary moment is what is taking me back to the Constitution moment, and somehow trying to see connections between the two. I start with the last speech delivered by Dr. Ambedkar at the Constituent Assembly on November 25th, 1949. And there are two parts of that speech which I think are might pose certain questions around what I mean by contradictions. One being, and I'm quoting, democracy needs to be maintained, not merely in form, but also in fact. Not to be content with only political democracy, social democracy needs to be the base of political democracy. And there is a way in which he is in this speech also defining what is social democracy and saying cost of the other, but as what he is saying, a union of trinity. And I think in some senses there is a lot of worth in bringing these three together and understanding also this current moment as the need to talk about the three. And I think as I'm speaking, as I'm saying this, I'm kind of in conversation with the constitutional values that Pritam talked about, where fraternity did play an important role. He said that on the 26th of January 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in socio-economic life, there will be inequality. Continuing this contradiction will put political democracy in peril. And I kind of think that, some of the conversations that we've already had, this greater emphasis and probably the sole emphasis that has been placed around understanding democracy through a very narrow political lens of voting has in some senses find resonances to what is the kind of anxiety that Ambedkar is suggesting. The other thing that he says is a second principle which we are wanting is in recognition of the principle of fraternity. So there is some kind of I would think, an understanding here that fraternity actually doesn't exist when, during the framing and the discussions that are happening vis-a-vis the Constitution, because a common brotherhood of all Indians, a principle which gives unity and solidarity to social life, is something which he is saying is still to be achieved. So I move on to think that we, the people of India, the first few words, which substitutes the expression Indian nation, finally, has definitely acquired a new meaning in contemporary times. So, we, the people of India who adopted, enacted and gave to ourselves the Constitution on 26 November 1949, one actually wonders that in the reading of the preamble, as is happening in recent times in various public sites of campaigns or in neighborhoods, seem to represent, to me, three things, and these are of course early thoughts being part of some of these readings with people. One, the persistence of the contradictions, but as well as ways in which fraternity clearly is threatened, however, is also something that is desired. So how do we make sense of both of these? Second, from the preamble or even the Constitution being technical civics, something that we do in school education, to whether court judgments considered preamble to be a part of the Constitution or not to be part of the Constitution, that of course a lot of law school discussions entail, or political science engaging with it from more of a state formation moment, it does seem to have emerged as much more than the letter of the law, and to me that is a valuable moment, of course a moment which needs to carry on in some ways. It definitely cannot remain only with the performativity of the reading itself. But the words have direct meanings in the everyday lives of the citizens of India. People are giving to themselves meanings that the preamble has already enshrined. So this contradiction in law and life is something which is coming out together as well. And the third, this reading of the preamble, the singing of the national anthem, the carrying of the national flag, all markers of the nation state, all of which could probably also be conceptualized as Durkheim had done as civic religion. All of these are being used to reclaim and reaffirm our belief in liberty, equality, fraternity and justice. Samvidhan has been declared to be the Oxford Hindi word for the year 2019. The Indian Express very recently had an editorial which says that it has come to the streets. It has been claimed, understood, engaged with, interrogated by we the people in different languages. And I have also kind of felt connect in the ways in which when you read the Constitution in English and when you actually read it aloud, maybe in Hindi or Bangla, what are the kinds of words that changes. And very recently in one of these readings, one realized that the word fraternity in its Hindi translation is used as bandhuta, and in the Bangla in the Bangla word, however, bhatritto is what remains, which is closer to fraternity in a certain meaning, which probably isn't when you think about the word bandhuta. So how is it the plurality of the languages and the way in which it is reading the preamble, I think is a very, very important, important becoming that is happening, and we need to kind of engage with that. The second bit that I want to move to is, as I said, the women's question vis-a-vis the Constitution with its contradictions and resistances. So we also see in the current moment, women, young and aged, across communities are present, sitting, and there's something to be thought about the ways of protests that are being used, where sit-in is a very, very important mode. So in this current anti-CAA, NRC, NPR protests, they are in huge numbers. For women, the question of citizenship has been fraught since the partition. Because I think there is relevance for us to remember the Abducted Persons Recovery and Restoration Act of 1949, which definitely had a deeply paternalistic, a completely non-consensual mode of recovery, where the vision of maintaining the nation's honor was supreme in the recovery of women. And this is actually happening after you have the Constitution, which has guaranteed equality of sexes. So that's what I'm actually thinking about in terms of the contradiction or the fracture which exists in the moment of becoming itself. It's also important to recollect another text which I feel has been very less engaged with, even in feminist scholarship in India. Just a couple of people have written around it. Women's Role in Planned Economy, a document which comes eventually in 1947. But as a result of the report which is presented by the subcommittee on the women Subcommittee on Women on the National Planning Committee of 1938. This document, a process of 10 years and eventually in 1947, had recognized women as full citizens, free to develop her potentials, unhindered by social problems. And the word social here in the document has constantly been interchangeably used with familial. Social problems, as well as the call of the nation state for useful citizens and productive workers. So there is a way in which, the understanding of women, which the report affirmed, is in order to help women to become useful citizens and productive workers, she must be assured of her fundamental rights. And social and familial problems shouldn't be hindering in order for them to become these full citizens. But the full citizen understanding is actually a useful citizen understanding, clearly coming from a socialist understanding in this particular text. From 27 women, and this subcommittee was ironically, interestingly, all women, 27 of them, who wrote this report, Women's Role in Planned Economy. As we move ahead, we see that there were 15 women members in the Constituent Assembly. And, much before theoretical understandings on intersectionality actually existed, if we look into the composition of these women members, we would realize that they are from different communities and different regions. I'll quote, very briefly from three women and the kind of speeches that they made in the Constituent Assembly. First, Dakshayani Velayudhan, who is the Dalit woman representative in the Constituent Assembly, she had said, and I think the reason why I'm using these specific quotes, these 3 quotes, is to remain with the anxiety question, and the anxiety question around contradiction, but also hope question that is there. So Velayudhan is saying a Constituent Assembly not only frames a constitution, but also gives the people a new framework of life. Communalism. And I think this is the same sentence which is more important. Communalism, whether Harijan, Christian, Muslim or Sikh, is opposed to nationalism. It is the moral safeguard that gives real protection to the underdogs of this country. There's a very interesting moral, ethical undertone that comes both in Dakshayani's speeches in the Constituent Assembly, as well as Begum Ayaz Rasool's speeches in the Constituent Assembly about this kind of a moral responsibility that actually the majority community has. And because there is a moral responsibility, therefore, both of them are actually arguing against any form of reservation. So it moves to that. It of course moves towards reservation, but this role of the moral responsibility is something which is supreme. The second is actually from Begum Ayaz Rasool, who was there in the Constituent Assembly as a United Province representative. It is for the majority to realize its duty not to discriminate against any minority. Again, I would think this, duty, and there is some thought to be made with respect to, I don't know, maybe reclaiming fundamental duties at this juncture, although its origins are not necessarily very democratic, but actually to go back and see what kind of duties are being talked about in terms of playing a role towards fraternity in certain senses. Finally, Hamsa Mehta, who is in the Constituent Assembly from Bombay, she says, what we have asked for is social justice, economic and political justice. Equality can only be a basis of mutual respect. I think there's some conversation that Hamsa Mehta seems to have with Ambedkar's anxiety about if you only have political democracy for a long time, then there is surely a peril. We need to think, move towards social democracy. The process of constitution making, as we all know, was lengthy, dialogic, constantly contentious. I've never felt that it has been a very consensual process of constitution making, but definitely futuristic. Hope and anxiety coexisted. Some of what we are witnessing in the current moments, those draw our attention towards the contradictions that were being discussed during the moment of the framing of the Constitution. Post the criminalization of triple talaq, post abrogation of Section 370, and post the process of carrying out the NRC in Assam, I think all of these legal, political, constitutional events have happened, and we are at the post of all of these. What are we seeing today? On the one hand, it seems to be a call towards azadi, freedom, individual liberty. But I think there's something to be thought of more deeply in terms of being more insightful about what do these words mean when we hear women say, I have to run away from my natal family to get married. How do I get my documents to prove myself? So the question of citizenship with respect to women are intrinsically also connected with, those familial and social values which could have become a hindrance, which the women's role in planned economy document was literally talking about. Or when women say, Samvidhan bachane nikle hai, aao hamare saath chalo, we realize that it is not only a political moment in our history, but also a constitutional moment of revisiting everyday experiences of both resistance as well as resilience that the people of India are showing. Thank you.
And I would say, focusing on the contradictions, the anxieties, the dialectics of hope and ambivalence, and so on and so forth. And the plan document that you also refer to, I think, is also a document which has not been perhaps analyzed from this vantage point. We have had series of write-ups on that, but not from this. So I think this work will go on and we will explore further. Just to conclude, just one or two points, one or two observations. One of our former students from my university, from my department, is now doing a study on the women who are in Park Circus, the congregation that you have, and there they were asked that because they come mostly from a particular community, minority community, where they don't usually, they come from a background where they don't usually stay back at night, and don't usually move around unescorted like the way they are now doing. So they were asked that why are you doing this? And they said that it is our responsibility to defend the Constitution. And when she made a study of the male participants there and the women participants there, they saw that preamble is being much more effectively analyzed by women. Second is, I think, Vishnu, I saw on NDTV, was in Shaheen Bagh, and he was asking them that why are you, the women participants there, that you don't have any leaders, how long can you go on with this? He was referring to the Shahbag Square agitation and all that in comparison. After a point it fizzled out and all that. But the one woman said there that you are wrong, you think that we don't have our leaders, but the Constitution is our leader. So this again, shows how perhaps Constitution has come back on the streets itself and being reinterpreted, perhaps, reformulated. And this panel, I think, is a wonderful panel where we had seen, they were revealing different dimensions, different aspects of this complex thing. Now I would, can we have 10-15 minutes? Because we started at 10 minutes, okay? So the floor is now open, so please, you can have your observations, questions and queries. Please be brief and identify the speaker to whom you are addressing.
If I can use my organizer's privilege.
Yeah, of course, yeah.
My question is both to Sudhir as well as Sudhir and even to Professor Sinha. One is the issue of citizenship in many ways, as Sudhir says, is connected with who's part of the political society. And that's perhaps one of the fundamental questions. And do we think that Indian Constitution's failure to take a clear affirmative position, either on the jus solis or jus sanguinis position, has fed to that fundamental confusion as to how we deal with this issue of who all are part of or legitimate constituent of this political society that we see as India? And secondly, the issue of fraternity and solidarity, can that be divorced from the larger questions of social and economic justice? And isn't it just a coincidence, or more than a coincidence, the fact that neoliberalism and the greater collapse of social and economic rights in many ways has paralleled this emergence of xenophobia and concerns about refugees and illegal immigration? So can we really see these two as distinct issues, or we must connect the question of citizenship with the broader questions of solidarity and both social and economic?
Thank you. We can, from the students,
Professor Krishna Swami and Professor Pritam Barua. Because you guys mentioned about the Smith Commission debate, and with regard to that I wanted to ask this question. I face a very fundamental question when I was teaching Smith, and my student asked, how can you teach a philosopher who was a member of Nazi party? And this was a very fundamental question for them. And I said, I should teach Schmidt because he said something very unique about sovereignty, and he also said something very unique about the political society. One question is, imagine if the sovereign decides that the exception has emerged, and to obviate that exception, we require redefinition of citizenship. Second, which Professor Barua has pointed out, that the neighbors are not talking to each other. Rather, they are more interested in talking to union. Now, if I take Schmidt's distinction of friend-enemy, they should be more interested in talking to union, because union is going to ameliorate their situation if they are within the quote-unquote doubtful citizen category. So how we will navigate through this catch-22 situation?
Any more?
My question is to Preetham sir. And so you spoke about how there's a need to probably have a relook at the 6th schedule. So what do you think is the alternative to the 6th schedule and to other articles like Article 371A in the Constitution?
Which is that when, and in that context I must clarify that I was speaking about communities within the Northeast and not in terms of people who are not part of the National Register of Citizens. But even here, the differences, the very idea that the union will ameliorate these differences would go against the logic of having asymmetric federalism, which was that we will decide for ourselves. So the philosophical justification for this kind of asymmetric federalism was the idea of self-determination, that these communities who have distinct cultures and cultural identities, they will be able to govern themselves. So if you provide a constitutional instrument to say that we are going to solve your problems by protecting your identity, etc., then in that context I was saying that it would be wrong then to think that in solving your problems you have a lesser role. The union government has a larger role. So in that sense I thought that the logic is inverse, that if it was self-determination, then you must make it possible for all of them to decide this in a collaborative way, right? And I think the problem is not just philosophical, it is a sociological problem, because one has to understand that these communities share a very small territory and live very close to each other. To introduce a constitutional instrument which makes them not look at others, and which touches upon the other question, has led us to almost conditions of genocide between Kukis and Nagas, between the Karbis and Mahajongs. So at one go 35 to 40 people were being shot with automatic weapons. So this is something to be thought about. And your friend is not your enemy is the kind of argument that I was trying to make. On the larger Schmittian question, maybe I leave it to Sudhir and not to take up much. The second question is that what is the alternative, right? So I think that the 6th schedule and the other exceptions which were made, you referred to 371, there's a slight difference. I think in terms of the 6th schedule applies to a very small area with a large number of diverse communities which were not traditionally asserting themselves as nations. Not all of them had secessionist movements against India. Whereas the others, the larger ones like Mizos, Nagas, who find mention specifically in 371 is that the government was actually negotiating with them. But on the 6th schedule, the problem was the government said that here we will try, even though there is no secessionist movement, here we will try and protect your culture and identity, because the clear idea is that there is very less cultural familiarity between the rest of India and many of these tribes. We should recognize that, whether you think it's culturally, whether it's racially, whether in terms of other habits, even geographically, to bring them together, we have to be creative. And I just think that the times have changed now, and one of the alternatives is that between these communities, so you may have protections against others, but between the communities in the region, you must provide incentives to talk to each other. So you cannot exclude, for example, say a Naga from going and buying land in Meghalaya, and a Meghalaya and somebody from Assam going and buying land in Meghalaya. That's what the problem is right now. You may say that we may protect you from others who are socially, economically more powerful than you, but we will not protect you from each other, because that will try and facilitate a dialogue. And those kind of constitutional instruments have been made in other parts of the world, and we should learn from that. Thank you.
Thanks to those questions set the question of citizenship decisively. is that in some sense a fault of the Constitution or something that's missing in the Constitution? And my response would be that no Constitution can settle all questions. Some questions may well be settled by some choices that are possible in that political framing moment. Some questions are simply deferred to some agency that the Constitution creates. It could be a parliament, it could be a court, it could be an executive, and some questions are simply silent. The Constitution says nothing about these questions. Maybe they're not even anticipated. So there are all sorts of puzzles that the Constitution may not be useful for. So the argument that a Constitution is not complete is not an argument about the weakness of a Constitution. I think the challenge is a slightly different one. How can a Constitution be a multi-generational instrument? By that, I mean that with the passing of time, new social constituencies emerge, new ideologies emerge, which may not have been, at the time of Constitution framing, part of the constitution-making process. Let me just give you an example, and I want to abstract from the contemporary political moment. Just imagine that India spawned a libertarian, metropolitan political class, that was just for various reasons found various parts of our Constitution uncomfortable. It just didn't sit with the political ideologies that they might embrace. What would they do with the Constitution? Do they have to junk it? Or is there a way in which new political movements that emerge across historical time adapt to a Constitution? To my mind, the problem that we face today is that kind of problem. We have an ascendant political force that was not decisive in the period 1930s to the 1950s, but today is politically ascendant. It wins elections, it wins majorities in many parts of India. How does a force like that make sense of the Constitution? I don't think that the reaction to the rise of various political forces in any democracy can be to brandish all of them as somehow being untouchable, or what we must have is a capacious enough understanding of the Constitution and the discovery of constitutional meaning to allow for everyone to kind of a big tent Constitution that accommodates various stripes of politics. So that's our challenge. I'm not saying, when I say various, I don't mean all. And so my response to your